boogera ku nsonga y'okkomyawo kkooti y'amagye katwegatte ku Joseph Serwoza ali ku palamenti akakiiko kakyagenda mu maaso ate tulabe ebiri erudde ku palamenti so katugende butereevu ku palamenti tulabe ebigenda mu maaso tujja kuba nga tubikutegeeza sigala ku Terefayina.
Legal sense really even common sense. So I think at some point, maybe this I should be talking to the UPDF, not to the minister. At some point, you need to revisit this principle. The officers have served, we've recognized them, they have retired, let them live their own lives. They don't have to be members of the army organ, top army organ by law. No. No, I think we need to revisit this. And I hope at some point you concede and we move on. Honour Minister, look at page 15, you like Uganda. Such other commanders and experts as may be co-opted by the President to advise the High Command. You see, if you are advising the High Command, then you can't be a member. I think the High Command can co-opt people to advise them, not necessarily as members, but to bring their expertise. For example, we have seen members of cabinet, but there are people who sit in cabinet and advise cabinet, not necessarily them being members of cabinet. You would find, for example, National Planning Authority boss or Secretary General of the ruling party. I don't know whether it's possible. Those who come around, they listen into cabinet and they can be advised, but not necessarily that they become now members of the High Command. You need to look at this critically, because you need the services of advice, of experts. But you can't have an expert and then you are saying he's now a member. He's coming in as an advisor. And that's the power we need to give to the President to seek advice. Mr. Chairman, there is a good innovation by the bill of cross appeal, where you can appeal to the High Court. I think it's close. Clause 57. You see, I still have a problem. When you look at 2, clause 2, 225, clause 2. I don't know, Attorney General, whether you're there. Subsection 1 shall not affect the operations of any sentence imposed by a court-martial other than a sentence of death imposed by the General Court-Martial. You see, it means that you can only appeal about death and whether the trial was proper, but doesn't affect the sentence. Why should you have such a clause? That if somebody has been sentenced to life imprisonment, for example, and then the Court of Appeal has found that it was an illegal trial, the sentence is not affected. That was my interpretation. I could be wrong, because it said subsection 1 shall not affect the operation of any sentence imposed by a court-martial other than a sentence of death imposed by the General Court-Martial. So if you had other reasons, you could explain to see whether this particular clause is not going to be misread or misconstrued to mean that you can actually find impropriety in the sentencing, impropriety in the legality and of the trial, severity and or even leniency of the sentence, and yet it is not affected by the decision of the Court of Appeal. And why appeal to the Court of Appeal? I thought this is a subordinate court under 129. And subordinate to what? To the course of record. Meaning, if it is subordinate, it should be able to appeal to the High Court because it's subordinate to the High Court. Why are we jumping to the Court of Appeal? Yet this is a subordinate court. The Chairman, there are two things I want us to address about parallel or competing jurisdictions. Already there is a penal code provision which provides for some of these offenses unlawful possession of firearms, for example. And now all the firearms, you brought them here. What happens to the provisions of the penal code? Or we are repealing the penal code by necessary implication. Are we doing that? Because those provisions are there. And why are they there? It's because they are other weapons. For those of you who are used to weapons, I just see them. There are other weapons which are like for personal safety.
Kale akakiiko kakyagenda mu maaso era abali ku paalamenti abasasi baffe bagenda kubanga batuwa ebisingawo n'ebigenda okubanga biteesebwako okuva erudda eyo mu tteeserezo ku nsonga ez'okukomyawo kooti y'amagye ebeere nga ewozesa abantu ba bulijjo. So weekomere ku BBS Terefayina, byonna tugenda kubanga tubikutegeeza bali mu lulimi lunyaanyimbe, so tujja bikutegeeza mu lulimi lwaffe luno Oluganda. So amawanga ga Bulaaya gagenda kuwa Uganda obukadde bwa euro 48 nga zino zigenda kuyambako okukozesebwa mu kukuuma obutonde bw'ensi nga basimba ebibira. Ekitongole ekikwanaganya amawanga ga Bulaaya bino babitegeezezza Ssaabaminisita wa Uganda Right Honourable Robinah Nabbanja mu nsisinkano gy'abaddemu nabo ku ofiisi ye mu Kampala.
Okunoonyereza kulaga nti ebibira mu Uganda bizze bikendeera nga mu myaka 20 egiyise ebibira bikendedde okuva ku bitundu 24 ku buli 100 nga kati biri ku bitundu 12 n'obutundutundu 6 ku buli 100. Era gavumenti ya Uganda ng'eriwamu n'ekitongole ky'amawanga ga Bulaaya ki European Union baatandikawo enkola n'ayamba okuzzaawo ebibira. Embeera y'okusaanyaawo ebibira yawaliriza omukulembeze w'eggwanga Yoweri Kaguta Museveni mu mwaka gwa 2023 okussa envumbo ku batunda embaawo ebweru w'eggwanga n'ekigendererwa ekyokulaba ng'ebibira tebisaanyizibwawo.
We very much welcome all the efforts made so far by the government of Uganda to implement activities that promote our common sustainability objectives and in particular the preservation of forests. As you know, forests are the lungs, the life support system of the world. They help regulate the global climate and water cycle all around the globe, and their biodiversity is unique.
Kyokka abakugu okuva mu mawanga ga Bulaaya basabye Ssaabaminisita wa Uganda Robinah Nabbanja nti wateekebwewo enkola enaasobozesa abantu abatadde ssente mu kusimba emiti basigale nga bakuuma obutonde bw'ensi.
As you are aware, we have committed some 40 million euros initially under the current forestry program, and I want to express my gratitude to the Danish government that has added some 8 million euros to the initial funding, and that should be contracted to the end of this year.
Prior to the operationalization of the Forest Partnership, other EU member states like Germany through KfW and Sweden through CEDA had committed over $20 million, which had been locked in the World Bank over social safeguards and perceived discrimination against minority groups.
Enkolagana eno amawanga ga Bulaaya gaakagiteeka mu ssente obukadde bwa euro 48.
Why are we allowing the export of raw timber and import furniture? Why can't these furniture factories set up here? I therefore direct you and the Minister of Water and Environment to make sure that this practice is stopped immediately. 2023.
Uganda has been quite successful in setting up commercial plantations. And the forest cover has actually expanded because of those commercial plantations. At the moment, a lot of these trees are fully grown, but the people who have planted them cannot use the investments they have made for commercial forestry because the processing facilities are not there, are not sufficiently developed. The export is difficult because of the ban.
I agree with you that if I plant commercially, I would expect to sell it, but we are telling you that if you want to sell it, even if you have planted it commercially, you must replace it. So it is no longer just your personal product. It is now a sustainable product for the entire country.
Okunoonyereza kulaga nti Uganda erina obusobozi bw'okufuna ssente obuwumbi bwa $3 buli mwaka nga ziva mu bibira. Mu mwaka 2023-2024 Uganda yafuna ssente ziva mu mbaawo ezifuluma eggwanga obukadde bwa $143.
Kale bwe tweyongerayo Ssenkulu w'ekitongole ky'ebyobulambuzi mu Buganda Omukungu Najibu Nsubuga akalaatidde abalungamya b'oku mikolo